Hi, it's Pranav Barnott here from WYN Legal. Today, we've been supporting many people working for tech startups, tech scale-ups, and companies who are looking to make unfortunate redundancies given the financial climate that we're currently in. And the purpose of this video is to simply provide some guidance to employees who may have received information that their employment is due to come to an end, they're up for redundancy, and they may be given a settlement agreement to review and potentially get some legal advice on. And this can be quite scary. For some of the clients that we've been talking to today, they've never seen a settlement agreement before. This is all a very new concept. It's just not something they really expected. Quite a lot of the time, redundancies that do come about have just come about over a matter of a few days or a few weeks. So we're here to try and provide some free support to individuals who may be faced with this prospect that in the next week or 2 or 3 weeks are being asked to sign settlement agreements. So a settlement agreement is really a document given from your employer to you as an employee, and the cornerstone of this agreement is really the employer agreeing to give an employee perhaps a payment of some sort. Quite often they call it an ex gratia payment for the employment to come to an end. But in return, the employee is giving a guarantee that they will not bring a claim against the employer in return for this sum of money. And that's why employers like employees going to seek legal guidance on a settlement agreement, because it's almost a condition before getting paid anything as a goodbye payment that employees have taken some advice to ensure that no claim is going to be brought. So I just want to talk about 3 key things to look for when reviewing a settlement agreement. The first is being clear on what the arrangements of termination are. So being clear on getting any payments that are contractually due to you. These may be, for example, any accrued but untaken holiday pay, any expenses that you've incurred, and you may well get paid for your notice period that is due to you. So just be absolutely clear that you are aware of what should be given to you contractually under the agreement. The second thing to really look out for is think carefully about what your relationship has been like with your employer. Are there any concerns that you need to draw the attention to a lawyer to? For example, have there been any problems, any grievances, any complaints? Have you made any subject access requests? These are all things worth thinking about, talking about with your solicitor, because in effect, by signing a settlement agreement, you are making an agreement not to sue or bring a claim against your employer. So it's absolutely clear that you do just talk through any potential issues, see whether there are any merits to a case that you may wish to bring, and being comfortable with the idea that actually, upon signing this settlement agreement, you will not be able to bring any potential claim. So do have a little think about that. Think about any issues that you may have experienced, and just see, whether you can explore these with your solicitor. The third thing that I just want to really flag, and something that is sometimes getting overlooked, is that any settlement agreement should be looked at alongside your contract of employment. And the reason for that is because quite often the settlement agreement makes reference to your employment contract, and in particular in relation to something called your restrictive covenants. So what are your post-termination restrictions? Can you work for a competitor? Are you barred from working at certain companies, or taking certain clients, or poaching certain people that you work with? And these are all very, very important things that quite often you are going to be bound by. So making sure that you're clear on what restrictive covenants are in place following the termination date, discussing it with your lawyer, making sure that those restrictions are reasonable and enforceable, or if you feel that in this market you may need to negotiate some of those restrictive covenants, that's also something that you may wish to explore with your solicitor. So these are just some things worth thinking about. It is quite often a daunting process when you're, looking to be made redundant, or where you're given a settlement agreement. And really, the aim of a solicitor is just to help you through that process, making it as painless as it possibly can be. If we at WYN Legal can help you with any aspect, or just if you want a non-obligatory phone call about the terms of your settlement agreement, please don't hesitate to book a time in with us. You can book one within 30 seconds via our website, www.wyn.legal. Thank you very much.